Thank you, Mr. Dean. Mr. Riley?
Thank you, Your Honor.
Scott, do you need this? Or?
No, I do not.
Okay.
I'm going to present.
Okay.
May I please report, counsel, Stanley Ford. Good afternoon, ladies and gentlemen. My name is Scott Riley. You know that. We've talked at length. Prosecutor laid out a very emotional case, and he said thank you for your service. We do thank you. But we all understand that this is an emotional process. Mr. Gorman talked to you in voir dire a little bit about treating this as an academic exercise, because in order for a fair trial to occur, you have to do it without emotion. And it's hard to do. It's almost inhuman to do, based on the fact that there are 9 deaths as a result of this indictment. All right? But you have to treat this as an academic exercise without emotion in order for a fair trial to occur. You're going to hear about the investigations done in this matter. You're going to hear from the State Fire Marshal. You're going to hear from the Akron Fire Department. You're going to hear from the Akron Police Department. A lot of the evidence that you're going to be presented to is not a dispute. It's not a dispute that there were 3 fires set. It's not a dispute that all 3 fires were set intentionally. And it certainly is not a dispute that there were 9 deaths. The coroner, the medical examiner is going to come in, talk to you about the homicides that she ruled, and then the cause and the manner of all 9 of those deaths. Those facts are not in dispute. But again, as defense, we told you, and you know that the state of Ohio has the burden of proof to prove each and every element. Defense has the burden to prove nothing. But what we will do through the course of this trial is point things out in the investigation which raise that reasonable doubt. You're going to hear about the investigation from Detective Stewart. You're going to hear about the investigations from Detective Looney. We will cross-examine them, and we will point out some of the other suspects, other viable suspects, not Stanley Ford, but other folks in the neighborhood. (719) Foltz was the home of Lindell Lewis and Gloria Hart. And when I say that a lot of these facts are not in dispute, clearly all these deaths are tragedies. And you will never hear anybody from this side of the table for the defense say anything other than that. We understand that, all right? But still, we have to look at the investigation carefully and critically. Your jobs as jurors in listening to the testimony, listening to the witnesses, is to determine credibility, right? Determine what is credible. You also have to look at the investigation totally and look at that and determine whether it's credible, all right? What we're going to find out, Mr. D'Angelo talked about, in a sense he's called the folks that would come over to Lindell Lewis's house, as being rough around the edges, all right? I think what the evidence is going to show is that there is history of drug use, there is history of drug abuse, there is history of folks at that house not paying their dealers for their drugs, and you're going to hear about the conflicts that occurred in that house. And you're going to hear about another instance of arson, separate and unrelated to what's being alleged here in the state of Ohio versus Stanley Ford. There's a history of people owing money, and that creates a list of other suspects with well-known motivations, conflicts, and deception. You're going to hear about a man, I think, named Ronald Garrett. Ronald Garrett also at one point in time lived in the basement of Lindell Lewis's house, in addition to Mr. Hughley. And you're going to hear about shortly that he wasn't there the night of the fire, but you're going to hear about Detective Stewart's investigation to him. And I believe you're going to hear Detective Stewart say when she interviewed him, she found him to be evasive, not forthright, inconsistent, vague, and very elusive. in the course of her investigation, you're also going to find Detective Stewart issued subpoenas, obtained documents, and what she did find through the course of her documents was that Lindell Lewis had a life insurance policy. But the beneficiary of that life insurance policy was Lindell's ex-wife, Francine. Detective Stewart then followed up on that information and went out to interview Francine. And she also interviewed her then boyfriend, William Pryor. You heard about the videos, and Detective Stewart at this point in time has seen all these videos. And I think what the evidence is going to show was she went out to talk to Ms. Lewis and Mr. Pryor about this life insurance policy, that William Pryor drove a vehicle that she thought was similar to the one that she saw in the video. That William Pryor fit the general description of the person that she saw in the video. Talk about 693 Fultz. The prosecutor talked to you about Patrick Boggs. Patrick Boggs, again, 12 years before that fire, had been sent to prison for lighting Angela Boggs on fire. He had just been released. He was arrested that evening. And you're going to hear, through cross-examination, all the things that the police department did and didn't do as it relates to their investigation of Patrick Boggs. The videos are grainy at best. Not a single witness is going to come in here and tell you that they've looked at those videos and they've identified from those videos Stanley Ford. You're going to hear about all of the things that they did to try to enhance those videos. I believe they even sent them off to the FBI in Quantico, Virginia. But yet and still, not a single witness is going to come in and talk to you and tell you that that image that they see, they can tell is Stanley Ford. The prosecutor laid out Alarm.com. And the records, they say, says that the alarm was shut off by Stanley Ford. You will not hear a single witness from Alarm.com tell you that they, number one, even know who Stanley Ford is. That they know that Stanley Ford did anything, let alone turn on or turn off an alarm. I believe the person that's going to testify from Alarm.com is going to do it from the state of Minnesota. Probably has never been to the state of Ohio, and certainly doesn't know Stanley Ford from Akron. Stanley Ford has entered a plea of not guilty of these charges. We told you about that in voir dire. He has said through his not guilty plea, I did not do this. The state has the burden of proof to prove to you with the type of evidence that you would use in the most important of your own affairs. You have to keep an open mind and listen to the entire presentation. You cannot rush to any determinations as to what happened until you've heard all of the evidence. All right? The prosecutor laid out 4 things that he said were the key. Number 1, motive. Number 2, the video. Number 3, Alarm.com. All will reveal his ID. Alarm.com can't tell you Stanley Ford did anything. The videos cannot tell you Stanley Ford did anything. Motive is not an element. I think the judge might even tell you that. Motive is not an element in these particular crimes, or any crime in the state of Ohio. Hold the state to that burden of proof. talk about 1370. You were out at that scene. Pay attention to 730 Falls, which is right next to 1370 Hillcrest. In the area behind that house. You saw it today when you were on your jury view. All right? Take in everything carefully and critically. Do not rush to conclusions. The same conclusions that the police department rushed to. All right? Judge it carefully, critically. And when you do that, you'll know they have not proven Stanley Ford's guilt beyond a reasonable doubt. Thank you.
Thank you, Mr. Riley. All right, ladies and gentlemen.
So, as I indicated to you earlier, we're going to adjourn for today, and we will start bright and early tomorrow morning at 9 a.m. I want to remind you of the admonition I've previously given you concerning your conduct. It's important for you to be fair and attentive throughout the trial. Do not discuss a case amongst yourselves or with anyone else. This includes family, friends, and the media. You must not post or read anything about this case on the internet or any electronic device, including your cell phone. Do not watch any news accounts of this and or watch any type of reenactment or replay of anything you've heard in the courtroom today. Any such discussion, if discovered, could lead to a mistrial, which would severely compromise the parties' rights to a fair trial. Do not permit anyone to discuss this case with you or in your presence, and do not form or express an opinion on this case until it has finally been submitted to you. And so as you can see, this courtroom, compared to Friday, is a little different. It's a little muggy in here. So again, dress appropriately in layers if you choose to, and you'll have access to the jury room. There's a refrigerator in there if you want to bring your lunch. Tomorrow we'll be here all day. You can, of course, leave the courthouse during your lunch break. You can go downstairs to our cafeteria there, but you can also bring anything you want. So with that, we're going to adjourn for this morning and have you come back and be in the courtroom or in your jury room tomorrow by 8:45. We'll start at 9. And then juror number 13, I'm going to ask that you stay for a couple minutes. We want to talk about your schedule. All right. We're adjourned.
All rise. Need your notepads face down on your chairs. Please remain in the jury room, and I'll get your electronic devices for you.